Ghana bar situation abusia omoye lawyers and judges eku kesia ewo man konkonu Ghana mu a abusia ne omobo adwuma edi dwuma pa na omo nkomo bi aba betodwa abusia ne enya asem keto akora justice Dorinda Smith ata Kumasi High Court ba mfantini ahofefo ono ene tena maame akosia sewa odobroni na abusia panin sensem isu a at the end of the day, no team legal wife of Ubi Trabo Mammy, a trouble no try almost say, Mamma no Sebio, allege, Wajia demudie, and watching him, Mamma Kusha said once a gunechia, Webua Semno, Edietiano, and then Nahon Komobi, Ababi Tuja. And some Korea and so no, yes, Attorney General and so Edin Komobi say, we are judge, Nesse, Ube prosecute Ubia. Ana case biana but modern say ubenya evidences ewo ho ansana why prosecution ana say what the atembo no e de aba entesa we breach mra no enti ono say before say obetima prosecute obi no age say wanya evidences ejina so entesa ne 20 years korampo na umua asem no abusia ensem na doso kenofoli ata won sensem and I said in my song sensem abusia ensem ni bebre enene abetodwa na person be come ho akwadwinchiri mo hagusu yeke black media
enti nyina ebe ka bom ye no 30th of July eche na for ye asesa wan ebe cancel enti me bi say ebi ono ba out be ka eche osesa na adwe ni na you know otwifa so na
sanka debi sanka eko injunction on notice there Kenya working and be very good point adjust for lawyers ni be raise citing bad faith say nipa na kasa na obepe injunction initially no per say ye this day, so why now? So if what you are envisaging is to be correcter, then anka eba notice na ekoba say ye ti omo so asema anka ombe your arguments but when the ono na akwaje ne order yenim affidavit details a woman of the common court in a court issue injunction order interim for 10 days say a year bia maso na say or stop address for one can say or stop fufu bi oba address for din injunction. So the injunction order must be followed. So following the injunction order no means say I was say mo ko penal individual na mo serve no as simple as tetia o share injunction order numpa last paragraph
1 minute sebe me renfi and this address of din no boy I bet my ba say ye na address of na ye ni nyanom na ye
no and the empower address of na ye na yi no na ye na yi into mpacho o share injunction order na last paragraph no judge no cry kan you or say it should be directed and served on the respondent. Oh, obi reading injunction order in the last paragraph. It's address of na judge in CN7. In this corner talker say citing for contempt. Also we have proof of service.
Asema Agnes Ekweki say akofna jitu muso munusu date. We also have to understand the injunction order no. It was also a busuafo no. It's not all about akofna o. A busuafo no so kan ho no mo de injunction no koto eyi no so. And I proceed me bra.
Okay, the say injunction no. The main party busuafo opinion no.
Yes, and then I'm say, and yeah, bushing penny na a can't say what date not to Momonko, it was Akofna. And in this case, the main party was
Exactly.
Akofna is irrelevant to the injunction, Magnus.
Okay, so what can the side there? Bear in mind, they say, Papa, no, or no, of free maternal side, because it was a penny no woman, a paternal side.
And not for and no, some now can continue, but no, yes, say, and not in an injunction in your man for 10 days. No, Sanka, I do this at some point and Uncle Muni Nabeka could pay or court. Into honor, I can done a bit me pleading the case, I can say, I was a penny will crown on no crack and on any locus, only any.
Okay.
That better locus, but may I be seen only point. Or no crowd if you paternal side only case.
But I'm saying, okay,
but you say or mobile honor Into uncle do sa part ninti na say adwa na ntimi ankyere mu say bi ase na akofna but initially me the court na hwe na say okay ma me find injunction into so na ekyire ne ya hyeda be ka asem no which is exactly what happened to ma me bempo ma mo no ye the injunction no ko so na yesa reverse ye yesa ma mo court date so o mo nsamra after a year no can you say busuapeni nkoye na ne emeka e na o manko is the same thing with celebration of life na busuapeni ko di injunction no ye mo me date after so mo mra ne entina ni mo asem no mu te no na yese o matu aheda October no enti emu ko ni do mu nyamoye
Prestige, me kai say o ka wa ha say I too late to apply for injunction.
I this is my kind last paragraph from the two honor. Also, it is further ordered that the order shall remain for the period of 10 days and shall be brought to the notice of the respondent.
There be respondent essence also.
Respondent.
And there's a essence of Suntakusia Chim.
There be essence also.
And now one a respondent.
Adjustable.
One a body do injunction order.
Or no adjustable.
Into until now, court in the cano. Transition can a Omudin Bemukano.
And come
on. We're chin in the crowd. And I say, who said, judges no. Omunim deal. Omutim ratio. Ti o ye intina ti anka mi hu affidavit o mo file ko ya ene na be kire if you na affidavit mi kwa na eye deficient if you na na mu nyedu cause anka mu odu a anka the judge will further order say transition no mo mu en release funu ati ase ti bia na ina wo he o for injunction expert because say other party no only how to rebut whatever that you are saying in Nia obe kano judge no be share with interest na waye ni yama because waba experty inte bia obi twa le senyo me bia obi hu senyo me rekwan hia on fan kan na waye ne ebeboa into that is how it normally done into no I just have for safon kwana ye injante no ye injante transition no order stop transition and I could see a question back on so say almost a body in I was made politics Maminka Central Ghana wo better place be anywhere a change transition I'm telling you forever say they catch say I did a harness better place be anywhere Ghana ho better place
no there's another one but on your popular a UK there no
sister to transition transition
same thing no because
baby
free UK no.
And I make us say
free UK
baby
no, I could say and I make us say I didn't dear me can say be ni ho me say better
better and I make sure
exactly.
I'm telling you a lot of people don't even know that especially better prestige me because macho
transition genagidi
there's a real feed the American no but komo ha ne
let's not do
there's more
Never Magnus. Let's not do any advertisement for any company.
Okay.
The whole thing is say I just have for onion never.
Yeah.
And now with Adiana no no she knew certain people will try to get injunction. So some of us truly believe say initially need your body need ultimate transition when a boy.
No move.
But she moved the body at some point because she knew say injunction semi ebebem into movie body no cause no name say ebeba into at this point you know even the other party now wo do omo call here now wo kase say no it's not there me want to me address Gracie a little bit. Gracie Akotma is not a party to the injunction who read the injunction order na ebusuya penny from a friend say
Asumanya.
And all the address of court. Akofna de but akarini ade o shako o year for support no need injunction so. It's not about Akofna.
He's sworn I Odobo read it well.
Ebike meba. I got to say the thing say Akofna no or no so file supplementary affidavit to support no nyabuche jakusa kana right maminche akofena anya party onye plaintiff onye respondent. That is the law. But ubetumi abua obi asema okokano court by way of filing a supplementary affidavit to support the person. Na enye wo na ade asem na be court. Ti akofena no or support his opinion with a supplementary affidavit, but enye ono na ade asem no court. So what I'm saying, that is how it is.
Gracie, I don't know in the Superior Court of Judicature. In the High Court of Justice. Yes, no, but Abushapain Adumanko Nyantechi. Abiana Kotoko Royal Family, AB 51, Orange Street, Esumaya versus Sarah Adwa Safo.
Court ne ka so ye
Ono ya Abushapain.
No, ka so ye plaintiff and now ye dey.
Yeah, plaintiff slash applicant, yes. Versus Sarah Adwa Safo defendant.
Nyabuche. Plaintiff no omo ye ba kwa na mi.
Bakon.
Nti no akusa ka say Abushapain na different. Yeah. But who ready affidavit ni who ready court no order ni mu dia court ne say akofinancial the supplementary affidavit by eno nya na party eno no enya akofina party. But what I say
yeah, because I said the affidavit of Nana Kwadwo Safo Akofina of GE 525647 filed on 27th day of July in support of the motion ex parte.
I say in support, there's a supplementary.
Yes.
And the order and the order. Nipa be 20. Come na meba. Nipa be 20 bit ma file supplementary affidavit to support. But na nya omo na emo plaintiff. So plaintiff no dey Abushapain na dey address for court. Into obi person or cite address for contempt. Akofana dey ni hu ni. Abushapain no na also cite address for contempt.
We see.
This what I say.
Yeah. I'm of the view say enye the lawyer no copy injunction na say
okasa dey moye o.
Me say enye I'm of the view say a lawyer need because the lawyer need could have added the church to it by going about baby a umbisi papa because baby umbisi papa e sorry ni dia and sorry so support akofuna. So if omo ade assuring as one of the defendant preventing them from having the program at that church premises, definitely the church would have been saved and that place would have been corded off.
Kobina, you know, can any law. The matter tilty say a year bra, nipa ba kope, ena ono, oni mubutia, or more title to body no. Abushapain any the extended family. Church in them, into church into me party. Into ni for which my father's had na Abushapain asa.
One of the defendants because baby no be see papa no na facility ne your church ne dia.
Into all can say defendant na go meet him the asori na kan.
Asori na kan so that they cannot.
Oh, and the meet me person e basa na yansen nim che say enya asori for ya na attack of nature na Abushapain nachi.
Oh yes.
The basa yansen dem but I go meet my iron side but the basa yansen dem.
Welcome na binti asade no anyway to say. Me I will say it I've said it and I'll say it again. So address for mu push ni say one prayer ma wunsi adwa betimi akose ni papa wo baby no akondo ya
exactly adwani ne
just so many dey bia amana da ho
bia wo kose ni ya mo na mo be su
just so many amana da ho da bia
mo na mo be su enye ono address for ni be su inti saade ni de eno no hwan na ebe ha no ha wo bia but prestige me pacho ma me say last question me say mo ma ni tema ko no why na you move on from here me pacho wo asori so free asori lawyer yi wono an na sa ne papa kantanka oka omo ne papa kantanka tro wo yi afei wono na wasada ne abusua lawyer yi Ekope injunction ama ebusuye. Isn't there some form of conflict?
Because that was a question though. And yes, motion in that Kumasi quarter. Breful. I say, Akusia, I'm going to respectfully decline this invitation. Be in Chiamika, and to us.
Because it will say, I'd rather never be some of us want to consent. But and never be also swear. What shall I have any can? Well, because
That's okay. I drive it very reasonable or maybe as a point of law. What the main answer
because Omuyama hunt since a very actually not so case or Sana or she a bayo. It's never much all.
but on the day, a mechanic has said Ghana laws. Oh, and I'm Rebiano exception, then a wood.
Oh,
Law, you become an exception. But normal language, they become loopholes. Exception, a wood. We are someone, but a very good lawyer. Obeshe asemno. Na wahwe enho akade ene enho echiwade eno na obeye hu adwuma na wetumi aka wasema yeden ama the one for good lawyer onim akade na echiwade ne those things na asem no beba ebia ye ndi ma ube fi say obi akutua BE but na entesa said nam case say bia na ekwa happen na kan ha nse de bia me kan some me say there are ingredients okay say me be kwa me de criminal law criminal charges any proven beyond reasonable doubt etoto say we ya ben kwan ho okay I can say we ya ben kwan your ingredient bi o ha intumi nyira mfirim uma say ingredient no e yira firim a that is enya ben kwan na waye
and how are you?
say na may vindicated. That is how the law works. And the lawyer, your duty until our school to know the ingredients, the exceptions. I did be an actually getting your woman in auntie, who be the assembly, wouldn't be the befa.
One will say, prestige over Kaya, they na omoko ready well. Me can say, I dare about what means yes, and no crime so how decline it. Now make us say, how can a lawyer help their client to draft a will? Na what's now how my clients na kase me wua body no me bass me si na yem fama no me bass me si ni
Scrolling to the sleeping okay.
knowing very well say Ghana mremu no enye ba e na body ni ye ne de say no kwa wo decline ye on say it goes back to show say wo share injunction application na it tells you say wo lawyer no kwa wo nim say akofna no kra no regardless of whatever was said in the will, no, only locals to file an injunction against address. Oh, incident me some who send and not just a woman client or clients, no. Who now will boy no man a tray and another crack and say prestige.
I say we so the same way one and our done me and some patcho.
Because they say Sanka will no crampo waiter. And so with the master come the world no crack or seeking for injunction. No matter say, Papa Nessa of insanity. But you know, as a legal person, you know, says I will not deny my client to train and Drew baby. Yeah. But you allowed it. Into say it's like o client no wish no say as some man do your mind papa he's twisting he's utum say no both no cause near my open arm into who do you blame omo hard you know mpam to mommy movie on why akofna ni omo hard if I tell said now if I tell prestige yes starting free home said now temakulu and I'm patch me but say na need no
Said the name, Christine said the name at Tionu Tematu.
Okay, to me, Pacho, yes, start here for him. Initial charges, Nana. I think so. How a great start.
Mama, a breakdown of the course. So, she was.
Quick as I know I started. They say no. Ebe se me hu say ensa wo mo whatever. Omo wo VIP wo ana. Ala wo nyina go inside the wagon.
But me call order. I just say Obama dia frɛ near wako. Okay, so Pacho said the name Christine Atinu Tamaklo. She was arrested and she was arraigned before a high court of competent jurisdiction. Now, judge are not tickets, my lady Ifia Sewa Saribotri, one of the good judges at Yewo. And she was charged with 78 count. Tell my check count muwahada. Okay, my means I repeat it. You cast a count of charges. Charge biano, you statement of offense. For instance, ABR stealing. For instance, ABR assault and battery. For instance, ABR defilement. Those crime be about timbiano. And no, the statement of offense. My statement of offense now. No, I'm a particulars of offense. Particulars of offense no. And no statement of offense no. Nti stealing na. E be chere say bia e da ye adwada. Nipa si mesi a ofri e bia tamale. A ote ha. Oko mami asi mesi fie. Ina okohu say bayere bi da ho. Ina ofa ya wa bra wa mbo mami na manye na do ko no koton no. Oni eska gu no botum. Ska onya ye eni. No, what can fefe near particulars of offense. Now, say Sani Pano or call my adwa fee no, ebi or ni fee and pabe 7 p.m. Or could we are in a bayana, and or call Sister Agnes Sufi a we are 12, in could we are and pay and also about Cosia T fee and number 6, in could we are in the buyer. The Nina is stealing back, stealing in count 1, count 2, count 3. Nina so no Obama particulars name. Into the statement of offense never the same, but particulars of offense no and maybe different. The statement of offense never the same, but particulars of offense no. Sana etie. In another way to also understand the count, me say. Oh, another way to understand the count, me say. Ebia nipa no ko wi abaye no odinkan fa abaye first one ofa first one wi no ina osan fa second one ni nipa ba ko na o te say nipa ba ko wi an be miensa na se 9 ten na be sa na be count 1 count 2 count 3 intino emra no e kire say every at section 109 subsection 1 of Atetna or says will be the bonia. I will say count bia no eye baako. And I will say count bia separate. Yemfa count we enkofra count we. Ebasa na ebeye duplication of count. And I be duplicitous. Eye duplicitous. The court will invalidate those charges or be setting anybody free. Into for instance, say nipa baako for o say we are bayere no one check count nim now as I could repeat it bayere na also we are na on a different count with the same thing court no ebe bogu and running stress or section 109 subsection 1 of Atetna ewo. So, Miss Ationu, the Attorney General then, Godfrey Dame, a charge on 78 counts of these categories of crimes. Or say stealing, conspiracy, willfully causing financial loss to the state, causing loss to public property, money laundering, improper payment of funds, any unauthorized financial commitment and breach of PPA Act. Just say, sir, offenses we nyina no. Ebia no yenya ho count. Into okeka count ni na bomu anya te say charges kwa e dia bon 78. Tipa ba kufu. The charges ba ku 78 8 in abono na oba try na edru maybe na so kwakosa na ho yare ina oba US hana once anko Ghana bio. So they tried her in absentia. Okay, Article 19 now I kind of say if the person is unreasonable, unavailable, the court can move ahead to try in absentia. But I want to say maybe can I say may I have this problem? And I make I say maybe may instruct me lawyers. I'm on my Supreme Court. I could challenges try in absentia because me who say you're unconstitutional. Me who say try in absentia they're unconstitutional. Say nipa na ma the trial should terminate. Because you cannot crucify someone without hearing the person. In his about my child, say me want to say, "Obe try me in absentia." Me who say upon true and proper interpretation of Article 19(3), the frameworks of the Constitution, on main intent or understanding in Article 19(3), and yes, say I will say a trial will be in absentia. I will say nipano or you're present na you're trying. Me in future I will challenge this. I'll make sure say that the Supreme Court pursuant to Article 131 interpret this provision. That's how I try in absentia no. It true because I don't believe in that. No na ya kwa say bibi sa bad because na ma mini ni one our canasem. The charge is not the born no na ye jailing no. Ye jailing the 10 years to run concurrently. And of file grounds of appeal. No only Ghana and file grounds of appeal. In almost several or file appeal, in almost several notice of appeal no on the Attorney General. Intino, yes, started na omo oba in sawum no. Na asam so that court of appeal for some time na omo adjudicate. Internet say nanu ya na court of appeal so be man ruling. Ruling ko ba ya court of appeal say charges na ya the ball said now we training in him. Reason tia we training in him when they say grounds of appeal na said the lawyers erase ya almost 30 reasons in tia I was say ye omo client no a free prison no just say enyemra eko pepe. So the question is what were the grounds of appeal? So one normal grounds of appeal no that things say back on 9 or so. So the first one no almost say the conviction was unreasonable and couldn't be supported by the evidence. The one person say buana ye buana for no o hwa otum say ntiase nim wo mremu na adanse ye ba ya omugina so dibu no for no ene boni na yese wa ye no ene ne mfa. That is one person which say the charges were defective. You can say charges defective. With the between the normal English na actually say. You can say ADB or defect and say ADN a touch man. Ubo obi kwadu say bi anipa no area there and our cause stealing na. Stealing no yawo the definition at 29 I think section 125 or so. 12 I hope baby sir. You on the definition room. Send a definition no and I send I'm running define stealing no. Ewe ingredient was say you ewa nipa na yenim and so waka say nipa na committed the offense of stealing. Say ingredient no say ba kokura efri mu a the charge of stealing no entumi nyadwuma. Na sa ingredient no oh ma the particulars of offense na nipa ni ye no I was say contain sa ingredient no. So for example seven say yes stealing and I say seven say aha yes say etiamra say obi e shout akusia and our next chapter. So obi ba ha na oka say ako and I say ko and I say ta na so say atomra na e wa ha na o kire ni ya nipa ni ye ni ntu ka say atomra no mu a e was say sa ingredient na e wo sa emrana ya hye no e was say about particulars of offense ni there's so to me can say nipa na oba na friend na bia prosecute oba no obie na no obi na no ne na oka say akosua anaso oka say next chapter esan so obi na no ka akosua anaso oka say next chapter ninti no wa commit sa offense no say ankyeremu of particulars of offense nim ama yehu say ingredient no yehu bi of particulars of offense nim a ye beka tro say charges na dey abono no defective that is a touchema it is okay so charge obi with stealing na was say nipa no either obey dishonestly appropriating and I said dishonestly receiving na o receive so a was say na we receive no ade bi a ebe cause financial loss and I say ebe cause harm and ebe ma ahunchire bi aba so na sa ade na ono no o steal ye no was so de ade bi a ebe ma ono nya mfaso nti for instance obi di ne car ma na waton car no e discard gu botom dishonestly appropriating then no o chere particulars of offense ni mu a was say ingredient was stealing mu no and was dishonestly appropriating mu no was say about particulars ni samba particulars ni mu a it will be declared as defective charges because charge no dey abome no and no supporting evidence no supporting we no and then say nti mo kai Ernest Thompson odoboni nyo anko beka Ernest Thompson former Accra House of Folk boss secretary
no ani akwesi abo ami
oh okay akwesi abo okay Ernest Thompson former Accra House of Folk board secretary
Ernest Thompson.
Yes, lawyer Ernest Thompson. He's also one of the fantastic lawyers at Ghana.
Yes, issues no buy no.
Social security snake for charging snake case.
Yes, yeah.
Na attorney general charge no. Na charges the born no any particulars no mfa. Inti acquire man go Supreme Court. So my Lord Amadi Tanko eka say whenever into a Republic versus the High Court ex parte Ernest Thompson to okay say whenever a charge is defective and it is so grave to an extent that it cannot be cured, it is as good as setting it aside. Intino say charge, or the charge call say a defective, say defective no, a bit my say be a typing error and not the to make say a defective, but say a defective when the charge does not support the particulars of offense no. Say and support here, Supreme Court say that charge now they are boni pano. You should set it aside. Into Ernest Thompson, as I'm not going Supreme Court no, they set those charges aside. And I must Ernest Thompson why a free person. Into what they charge a booby, no particulars, no any charge in the ancient. That's any pan on your money no. What's my boy Akusiasum? What's my boy Agnes and the next chapter assume? Na story na a 1 year o can hono and chese my bon assume and then not the me continue court heading. So you can say the charge is near defective. So the court is going to repudiate it, to quash it. Intino, grounds back home raising no say charges no defective. Your grounds B to ground H now. And also say the judge committed a fundamental error of law. No him. And now mono edisa grounds no ekoye no. Almost into me and in the particulars. Into also share the grounds of appeal. My grounds na uch them. To also share the grounds of appeal na or can grant A. No watch them the judge committed an error of law. Also check the judge in the area or committee an error of law no. So one to man trade the judge in the area and man committee an error of law or cast any grounds in the over quarter. Court Becacho says our ground on a defective. Into almost no ground on the choir and only a ground B from ground B to ground H. When I accuse the judge and say, judge and I committee error of law. No, almost went to me and train a judge in the area. A judge of committee error of law. Into one of the court of appeal. It sa more grounds ground B to ground H no. Net is now Babeka ground first one no. Any or more other grounds and also here the sentence was harsh and excessive. Yes, Babeka those grounds no. Then the court of appeal entered into it. Omko share to kronum meka to kura mpɛsɛ sɛ ɔmo kɔ asɛm num ɛna ɔmo try sɛ ɔmo ɛhwɛhwɛ na ewu nti no ɔmo fa account biara saa account no ɛyɛ papa na ɔmo ahwɛ bɔne a mo so wayɛ no nti ɔmo fa account we causing financial loss na ɔmo ahwɛ ho bɔne a mo sɛ na mo ayɛ ɔmo hwɛ account of causing financial loss no na te sɛ yɛhwɛ story ɛda wa ɛno no bɛ support saa charges na it is said na no one committee saa financial loss no because in Ghana you can be a committee financial loss the person must actually give approval for payment in order for the payment to be deemed as say a cause financial loss. For instance, say you can say my cause financial loss to Akosia T platform here. Ebi a Akosia T platform you obey $20 million down. Na me makwa kupo bi say nipa no me registration my. Na me ma sign say yentua sa ebi a nipa so obey 10 million. Na me ma sign say yentua 10 million ma sa nipa no. Ye twa scan ma nipa no so ama me say registration no. That is me no my cause financial loss because me na me sign me na me ma approve say yentua say scan no ina yetua yeso no scan no eso man fa so ye anyanya ye ka say ye kwa koye na say causing financial loss into motion no Moses said na ma cause financial loss to the state said na me isu adanse a mo de call mo de call born ko adu a mo say no nti mo jeli ni 10 years yi bibi no e kire said na no ono aka say approve say nko tueska na mom nipa o approve say ntueska ye kan oferiata into person who charging for causing financial loss and you don't charge ni o approve say ntueska ni mum na mom ko charge ni ono no wa approve into the offense of causing financial loss no any ni amusi ni panaye no any evidence na any ni hia e be say court of appeal be dwiri ni na egu na wo dwirigu ye Moses said nam wa dishonestly wa appropriate sika enya aban sika ya aban sika tese obi de 500,000 e be share no filling station obi said nam isu no the question statement or say on kai say ana onni bibi a kire say obi discover be share no filling station in a court of appeal judges na share nsem net say prosecution no some person kan mo ya masem yi a Osanka nipa na ono no ka so this kind of said nam no Osanka prove bibi a friend receipt because what they demo be what the evidence of payment that is receipt you know I can say evidence of payment a receipt mo for receipt be am check what say anya bia o this kind of said nam no receipt or the man munye mo so a mo fa message bia a kire say said nam acknowledge receipt of the 500,000 ene na asem na mode to said nam so no ene na sa asem no ehun adanse no de ba court no ye dituma enyeji teno so mu dwirigu ye musa so say wasa ko teacher scam kantamanto market women say scan so no muhu baby scan afa well prosecution we witness oba court be di adanse ma wu no yes take MP for Ishia so ye bisa na under cross examination oh no say sebi o says can no mo kire ne kantamanto no mo di boss said na mi na no adanse wo ho says can e koye adanse wo ho says can e den e koye in a court of appeal na ebisa that's it can go ya say prosecution person mo yoma ya e wo sanka sebi o mo ekofa officers na omo ya involved in distributing those monies no sanka mo ko fa omo ba na ko mo so be di adanse say the biscuit can anko ye na officers on the ground see a bit to make distribute this kbia me na me hwe zone we so skebia ma me di minsa ni nyina entumi amma court the court of appeals and the sadia Such charge in some of the bonds. What cause it? What cause it lost to a public property? No, and also Jina in because I don't see a dark court name. No, that just say, sebi, a momre. This is a deal where a figure of speech American. In a nutshell, no, Oshe near judges no a kind. Not just say, they be some American has say, criminal trial, any good you. Sebi, I say, sebi, imperator so soon, be ye no. Unya dajia, untumi nye be ye. Emani nye ye, unya butre, eno oda. Untumi worry about papa mani ye, because obo pa krokro, any odo. Sana akwakoye. Inti odo broni nya pacho, read the paragraph, you mami. Paragraph. Pacho, utie me. Paragraph 60. I don't when you ruling it wrong.
Oh, na after but oh.
Read the paragraph, read the page 60, mommy. Page 60, no.
Okay.
Read the paragraph 59 and paragraph 60. So paragraph 59, no. A court of appeal causing financial loss. And omode omo imu aye e ba ye fa ho. E wa kakra but we read no aka na mama edin. Inti pacho me penyu fa mo ha. Pacho page 60, paragraph 59 and 60. Do hear somewhere omode kobo said na nyina na say it cannot stand the test of time. You say the American has said, so bet you be so be quite with them. And only a class 1 kindergarten of a criminal trial. But to prove beyond reasonable doubt, and better than that also. In the Nippon now, I accuse no bit or police to bit make us on casa. So I say my bonnie, prove the intel, say my bonnie. I say my bonnie, prove the intel, say my bonnie. Now, Eba Kuswa, court of appeal, and say, judge in the air, and say, I think in some no cause, I could do baby no. Not just say, a yakwa, yes, say, the similar quantum principle in criminal trial, no, said to prove beyond reasonable that not say, ya chana kaka. Say, criminal trial, no. Una within the Panagodian court, no, our your prosecutor, no, and now we your prosecutor. Una was say, who prove check court, and say, Nipan, in fact, with this happen, no. In this our bed, no, and that was so. The moment we shifted bed, no, from prosecutor, no, so I call accused person, no, so no, not to say, any criminal trial, na warrior. Into the court of appeal, realize, say, after the emotional trial, and send a trial, into my mention was an appeal today. The case appeal, no, this is how appeal works. At the first court, no, you the trial court, judge Bakope in an AT assembly. Into the judge back for the Onunu and the honority and in the legal opinion in our form. The court of appeal, a judge's answer. Into the assembly, course, what trial court, no. And one omubedi now so this time no omeyi judge ba kude free ho ina nipa miensa ba betena ho intino omubedi asem no tesenia judge ba ko ne te wodi asem no na no omuhwe judgment no no ma hwe records no ne course wo ho no na omo eja concern yeso ahwehwe ne course any judgment no eto asumu ewo mremu anase ento asumu ne omo ba be ya no te kata sama kwa apila ne omo ba be ya no instead of one judge odi asem no this time the third judge ne ba be di asem in sa judge ba ko no se wanye nyoma ya sa third judge sin na omo nyina bituma aka se ne oye no wanye ye ntin ye twem ta pepe na appeal etie inti no omo hwe evidence a omo ba na say do na say prosecution ko a shift bed na ko said na so said na mom na improve the case then say free him fa and also the any money that in criminal trial there's no way an accused person can prove himself or herself. Ghana you practice adversarial system. Adversarial say you go kwadu a wo abo nipa no kwadu no. Wo na wo say wo prove. Inquisitorial system no say wo na abo kwadu no na wo say wo sign uti. Ye ni inquisitorial system. You adversarial mu. The adversarial there. I was say wo na abo kwadu no prove beyond all reasonable doubt. And also almost say trial court no or shifted bed no prosecution no if ni e man some mo ka che no e bonenifra e wo mremu e bonenifra e wo mremu amane ntumi embie ne niye e wo mremu ama na ehu se nya prosecution e kono almost shifted bed na akoto accuse no so genoze basa na se try na entwaye. So they are unanimously, they are repudiating, they are nullifying, they are dismissing, they are quashing, they are acquitting and discharging, said the of all the 78 counts. And the question people ask is that 78 counts when you know the Baku Queen were born? Already judgment now to know say the prosecution then only a very bad job. A very bad job.
Is it that they overcharge?
Page 60. I go to page 60, paragraph 59 and 60. I go to Kasa.
Okay. In addition to say na omo proof beyond reasonable doubt, no. Is it like so mu overcharge yana?
Say na allegedly, nyankofo kan say akwa say yento net ningu nsuonum fish bi ebechini bia na afa ne saa and the saa there yama charges allegedly yama charges ne debre den ya ba ko be fa no. Now so in criminal jurisprudence enter saa anya wuti ni pana ye no e wo say uma adanse ni ingredient e kire say nya wa ye no so anya bia we di bone when do you improve a you be twem.
Because
the law is the law. The law is the law.
Nipa na momo peno no. To avoid the say nipa no cry no. You finding no guilty a. Mo ntimi in charge ni biom ne dey ntina de mo wo no. Mo fam build the case. Na mo fam build a stronger case. And focus on the little you have. Na chire no cry na say was some build a separate case a. To say they say to me or case back or case back on the michi. Ain't no that can equally work. But some mokika a boom overcharge it. No more so swa muntimi improve there was a more prover. To me, no, I'm a citizen of Ghana.
Yeah, I say opuni.
Ana kan ba beka yes ma wo kan person kan ba beka.
Charges in kwa.
Citizen of Ghana.
Abnado for opuni onko.
The member no kwa na metu no bo ase.
Tobo.
Because most times
can for allege so. Oja allege so obi antumi on.
Yeah, say we expect our prosecutors to know better and to do a better job for the country. And for the people, obviously. Sometimes, you must say a prosecutor be aye. Isn't there a way or not to see a bit me occurring like a best friend baby? Oh, like people, there need to be actions, consequences to people's actions. Now, much radiant here. You don't walk school. Now, wa we yam na nimu nia ba be prosecutor we are buying prosecutor friend say edi me ba that I'm not oye dey
ag
we ag mu na wo timi yes hello job sa me pa show allegedly we allegedly be
Akosia ni bibi
What about you
proceed gaba na akosia
allegedly
akosia answer na proceed gaba no akosia the old man was trying to push the young ones to the level they have not reached. That was the cause of everything. So there were experienced guys there who could do that job and do it perfectly. But the second time, all those guys were sidelined and taken away. We
No,
got the young guys.
Age there.
What's it? Yeah, oh damn it. It's shallow work. This is shallow work.
Yes, I don't know.
This is shallow work. Shallow.
Oh no, crowd.
So that was the cause of everything. That was the cause. President Bajabet Mabam.
Now, Miss say, they be I make us respected this current attorney general, make us respected attorney general. Yeah,
absolutely.
When you have a prosecutor who is also a doctor and also a lecturer, criminal law yankasa bebre. Unya ingredient na yankasa bebre. Oh, opening man about almost 90 something count. I think because then the count is how just say charges at the born could be 90 something, I say 80 something.
Why?
Calling that and so charge at the born there could be 100 and something, as I say. Before also charge at the born when it's could be 60 something, as I say. But also share Attorney General we are and go bit Marcus out to know. But or say or no. Charge are only evidence no on prosecute. And you see, his own party members came after him. Also, no. Nya only more evidence non prosecute. If you want to me charges no. 6 count pay. Ebia so no kasa ni nye bebre kakra bi heavyweight. The ingredients are all there.
Now, there ya na ebi mo mementi ase ne se asema na me ka ma mentimi kan ye. Because so we fact there were evidence. Now what charge nipa no kakra bi na win case na. The ones that you don't have evidence, eventually so when you have evidence, you can equally build a case.
The one that people to hail them.
Boom. Now if
the one that people to hail them.
You cannot retry the person. And our prestige, I don't know. Ghana money and
no. The moment the person is acquitted, the person is free forever.
Yeah, you can't retry the person. Incident, I want to me and for the little piece. Even if say, a friend is say, nipa number 7 5 years or 2 years a day, you would fair no court and build another case while the person is facing judgment and a bibisa. Now, it looks as if say you are causing financial loss to more causing financial loss to the state because the trial itself is expensive. And I will aid you no the state is paying you to make appearance. Financial loss to the state.
The money Ghana, Franklin could you? What's this car damage saying now? I'm afraid man with your says Garo.
I won't be making you financial loss to the state. Oh, I am now quite as I saw Mudini Padre dear go. Oh, Bronini, I read it, and now when you're ready to read.
My ready.
For my
59. Also, the impugn count 36, 37, 38, 39, 40, 41, 42, 47, and 64. Each alleging willfully causing financial loss to the state, contrary to section 179A, subsection 3A of Criminal Offences Act 1960 at 29, against the appellant alone counts 43, 45, 48, 52, 54, 56, 58, 60, 62, 65, and 67. Alleged conspiracy to causing financial loss to the state, contrary to section 23, subsection A, and 179A, subsection 3A of Act 29, counts 44, 46, 51, 53, 55, 57, 59, 61, 63, 66, and 68 alleged causing financial loss to the state, contrary to section 179A, clause 3, subsection A of Act 29, against the appellant and the second accused, count 69, 70, and 71, alleging causing loss to public property against the appellant alone, are likewise defective.
Defective.
Then 60.
and I can't court no opinion to in other words no the ruling of the court. The court can file say you know.
Yes, 60. In my opinion, the count alleging conspiracy to willfully causing financial loss to the states and causing financial loss to the states are incurably deficient.
Or say I incurably deficient. I could say
Deficient.
you can't be incurably deficient as you say. Oh, not teach at a brofo.
Madam Brofo,
Only you can't be incurably deficient. I could say I say crying say incurably. Let's say we are here. Enye ye. Let's say deficient no. We are here. Enye ye. So how did we get there?
They omit.
Oh, me fashion sorry. Make us go. Me facho kasa.
Or say they omit an indispensable ingredient of the offense.
I am Makusan Chemchi. Or say they omit the indispensable. Let's be an indispensable. Just say, Senna Quano, just say, a idea. Want to be in frame ingredient. I am Makusan Chemuchina, you be Brian Tiasse.
The particular acts or omission of the appellant said to have been willfully commit and by which the alleged financial loss was occasioned. The appellant was charged under section 179A, subsection 3A of Act 29, which provide causing loss, damage or injury to property. 1. A person who by willfully
court say is incurably deficient near charging no the bond. Into court ne ba be chirem charge na wo dia bond no. And we ingredient e was anka enu nti enu nimu a omu gina so accept my money free pacho to aso.
A person who by a willful act or omission causes loss, damage or injury to a property of a public body or an agency of the republic commits a criminal offense. 2. A person who in the course of a transaction or business which a public body or an agency of the republic intentionally cause damage or loss.
Into said the person who reading na we reading on.
Yeah. Top one the system.
Nina kakusi su say. Chese eya kwa say prosecution no then no biana omunni omedwuma like omunni omedwuma like omanyi omedwuma ye na ya kwa so omanyi omedwuma because ni amode charges na ankasa amode bae no monte ehun ingredient ase another the enkofo kase allegedly it was politically motivated no and no na cause one because charge under the seal of the Attorney General then there. Sanka all these ingredients. Oh, into the moment you bet you say our committee offense no. Oh lawyer bepe obetie offense or committee no. Na we tie story around it. Story around it then the particulars of offense no. No why he say ingredient na what's our offense no. Ebi wo mu ana. Se bi kra ni mu a obesa ta bonisem. Waka to say cool down and kahwe me ba mini wa nkasa te say obe show na so ye could do quarter no point out say my lord my lady almost so much charging for this ingredient was a war offense mu no enu see o hwe de almost wa kwakwe na this particular ingredient enim ti edi na nipa yo wa asem ne yewie oh enti no o hwe said nam eni senia try no edi na afa mu na initially really no buy na go for we di political military but you see she say Ghana na yekoye ni mu so obi anya judgment ni bi kan ya understandable no obi anya na say na mo anyi madwuma yi but everybody say we go this guy jail and we go this guy kan hunyan enso want to improve in a court of competent jurisdiction na won say asem so the a court trial court bibia tumisi ebi pa judge no she was taken over by the event a course so ebi na adwena ba so a court of appeal three judges in the court of appeal say judgment free when say go supreme court kakra bi na set aside so case is free court of appeal na go supreme court nia ye set aside no ya na bia ya akwa different in opinion but say on the point of law say pass on the committee an error of law there court of appeal because the judges there no they are the same as the judges at the supreme court just say we no yenyan call omo to the supreme court in the most in semi free court of appeal supreme court think 10% being set aside in the way also charging for causing financial loss nipa no choose can nanka wa charge na ka ho inti said now we be charging for abia preparation we say match inchoate offense wa ha ka say inchoate offense I say match mu ha bet match charging for preparation and e be kura we say abetment we charging for abetment